An agreement which is enforceable by law at the option of one or more persons. So here a contract comes into existence as soon as the luggage has been placed. So void agreement. What is a void agreement? A void agreement is which is not been enforceable by law. Now under this we have two types, that is express contract and implied contract. Hi and welcome to all dear students. I George William A, Commerce Faculty, Vidhyaashram First Grade College, MYSURU, a temple of excellence. Dear students, today we are going to the session 3 of business law. Before going to this particular topics which I am going to cover today, let us have a brief summary or the glance of the previous session, that is under session 2. In the session 2, I had explained to you about the meaning of law, what is a law, the definition of a law, then what is a contract, the definition of a contract, right? What is an agreement, and what are the essentials of a valid contract. So in today's session, we shall continue with the other topics where we say that it is of the kinds or the classification of contracts. Kinds or classification of contracts. Students, you can see in the image here, the classification of contracts are being classified on 4 bases. First is on the basis of enforceability. On the basis of enforceability. Second is on the basis of creation, that is on the basis of formation or creation we say. Then on the based on execution as well as on the basis of duration. So here we are going to understand all the terms which is coming under these 4 classifications of contracts. First, if we take on the basis of enforceability, we have 2 types of contracts. One is the valid contract and the second one is voidable contract. Now let us understand what is valid contract. What do you mean by valid contract? See, when a person enters into an agreement, both the parties enters into an agreement and thereby they are accepting what is being offered and what is being accepted, and it is been binded by law, which has been enforceable or enforceability of law on this particular agreement, and that becomes a contract. So a valid contract is an agreement which is being enforceable by law, and in this particular it says contract, an agreement becomes enforceable by law only when all the essential elements of valid contract, very much important, it says all the elements of the valid contract is present. Now which are the valid essential of valid contract? In the last class I explained to you. I'll just tell you some of the important essentials of a valid contract, such as it may be that there should be a consideration, there should be a contingent capacity to enter into a contract, there should be 2 or more partners to enter a contract, right? So this should be of legality. Like this, there should be all the elements present, all the essentials of a contract, valid contract should be there in that particular contract. Then only it can be called as a valid contract. Even if any one of the essential of a contract is missing, then that cannot become a valid contract. It becomes a void contract. So this is about the valid contract. So I'll just repeat once again. Students, just listen. It says a valid contract is an agreement which is enforceable by law, and when an agreement becomes enforceable by law, then it becomes a valid contract only when all the essential elements of that particular contract should be there in that particular contract. Then only it can be a very well as it can be a valid contract. Now moving on to the next type, that is under this particular classification of contracts, that is on enforceability. It says voidable contract. What is voidable contract? An agreement which is enforceable by law at the option of one or more persons or the parties, but not at the option of one or more other. So this is very important. So here it says an agreement which is enforceable by law and which is at the option of one or more parties, but it should not be the option of one or more of the other parties. Means the other party should not enter into that particular contract. That means the two persons who are there, who are agreeing upon to do or to agree on something and making a contract, only those persons should be there under this particular contract. Otherwise, if it is called as voidable contract. Now we can see the example here. A very good example is given for this particular contract, that is for voidable contract. It says A promises to sell his car for B for rupees 2 lakhs. A is promising for B to sell his car for rupees 2 lakhs, but his consent is obtained by use of force. Here he is using his force in order to make an agreement with B. So A is making an agreement by using his force. It may be coercion or the fraud or whatever it is. So it may be using the force. So when he uses the force, when A uses the force on B to sell his car, then that agreement becomes voidable. This agreement becomes voidable at the option of A, because he is using the force and there is no free consent on the party, that is on the other party called as B. So he may avoid this contract. So B may avoid this contract because it is by using of force by the other party, that is A. So this is about the voidable contract. Now the contract becomes voidable in the following cases. There are some cases where the contract becomes voidable. First is when a person promises to do something for the other person for a consideration, but the other person prevents him. This is important. Prevents him from performing his duties or the promise. Now A is promising to do something to B, right? And in that case, now B is not allowing A to do that particular work or the obligation which he has to perform on his part. In that case, it becomes a voidable contract. It becomes a voidable contract. So because he is not allowing, A is not allowing B to do his obligation on his part, when he prevents B from doing his part of obligation, then that becomes a voidable contract. So example, it says A and B, they enter into contract and B shall execute some work. B shall execute some work for A for rupees 1000, but B is ready and willing to execute that particular work or the obligation and willing to execute according to A, but A prevents him from doing so. So for example, I am calling a person and I want to paint my house. In that case, I am telling him to paint the house, but later on I say don't paint the house. In that case, what happens? My contract becomes voidable because I am preventing the other person where I said him to do that particular work, but now I am itself, that is, I am only going to stop that particular person in doing his work or in fulfilling his obligation. In that case, he can claim the compensation for the loss occurred to him. He can claim the loss for the compensation it has occurred to him. So that is about the other cases where we can see the voidable contract. In second type, it says when a party to the contract promises to perform the obligation. Now one of the party A is ready to perform his obligation, right, within the specified time period. Within the specified time period. But what happens? Any failure on his part, and if he is not completing his obligation, is not fulfilling his obligation within that given stipulated time period, then that particular contract becomes the voidable contract. Now for example, I told you that I am calling a person, a painter, to paint my house. and I tell him that within 1 week you should complete all the painting work of my house. But that person agrees. At the time of contract, he agrees and says, okay sir, I am ready to paint your house. But later on, he is not going to complete that particular work or the obligation which is been given by me to him. In that case, his contract will be voidable. So we can say that that particular contract is a voidable contract. Now students, coming to the next type of contract, that is known as void contract. What is void means? Void means it says not binding in law. So the contract, it is not binding in law. So here it is the valid of time. It is the valid of time in making it, but it becomes void. It becomes void. Likewise, when a contract which has been originally entered into as a full-fledged contract with the enforcement of law, now at a later stage that particular contract becomes void. Why? Because for not completing or his work, or is not going to fulfill his promises or the obligations. So here you can see the contract of import goods from foreign country. So here what happens, if a person A is importing the goods from a foreign country, and it becomes a void because when the war breaks out between both the countries, then you cannot fulfill the promise, that is of importing the goods or the exporting of the goods. So in that case, the contract becomes void. So void agreement. What is a void agreement? A void agreement is which is not been enforceable by law. Any agreement which is not been enforceable by law is an void agreement. Therefore, it says it does not give rise to any kind of legal consequences. So because it does not have any kind of legal obligations, or it is not been binded by law, that particular agreement becomes a void agreement. The next fourth one is unenforceable contract. What do you mean by unenforceable contract? It says it is in one which is valid, but at a later stage not capable of being enforced in the court of law. Why? At the time of agreement, that particular contract is a valid contract, but at a later stage you cannot take that particular case into the court of law and seek the justice for that particular whatever the loss has occurred, because it may be due to the technical reasons. It may be due to the technical reasons or technical problems, such as absence of writing. That is, whenever you enter into an agreement or a contract, that particular contract should be in writing. Why we say it should be in writing? Because that is the evidence or the proof later on at any stage. If any one of the party breaches that particular contract, then easily you can go to the court of law and you can sue him. So in that case, it is easy for both the parties to enter into contract, and later on at the later stage, if anything happens that is not binding by law, then you can sue him in the court of law. That is the reason it says absence of writing cannot be taken into the court of law. When there is no agreement, written agreement or the proof of evidence, how can you enter the court of law and say that we have made an agreement and he is not fulfilling his obligation? So it is not possible. Likewise, registration. If your contract is not been registered, then it can also be causing problem for you at a later stage when there is a breach of contract between any of the parties, and you cannot sue them in the court of law. And the last one is the stamp. It should be stamped and registered. Now fifth one is legal or unlawful contract. What is this legal and unlawful contract? It is nothing but it is an agreement which has been made by the parties. It is expressly or impliedly which has been prohibited or forbidden by law. This particular law becomes an unlawful contract or illegal contract. This particular contract becomes unlawful contract or a illegal contract, because whatever the agreement you have made, if that is been expressly or impliedly prohibited under law, then that becomes illegal or it can be an unlawful contract. Now we can see the example here. B is a person, a party who borrows 5,000 rupees from Mr. A, right? And he enters into a contract with the alien to import the goods which is not been allowed to import. So B is taking a loan from A and he is importing the goods from another person, and where that particular goods is a prohibited one, that particular goods is prohibited in entering into the country. So he is making an illegal contract. So this is why it says it is an illegal contract. Now students, coming to the next part, that is the next kind or the classification of contracts, that is on the basis of creation, or it can be also called as formation. Creation or formation. Now under this we have two types, that is express contract and implied contract. Now what do you mean by express contract? Express contract is nothing but whatever the agreement or the contract you have made between both the parties, and whatever the agreements and whatever the transaction you have to do, all that agreements will be expressed in writing, or it can be in oral. The declaration of terms and conditions, what you agree upon, will be in that particular contract. So the contract which is agreed upon between both the parties, and all the conditions and the terms which you agree upon to do in the future, that agreement will be there in that particular document, or it can be called as a document. So it says express contract is one in which the parties, whatever they make oral, that will be in the written form, and whatever the conditions and agreements they make and the terms and conditions, that will be in this particular contract. That is why we call it as an express contract. Then secondly, implied contract. Implied contract is nothing but here you are going to get, or you are going to collect the evidences or the proof of that particular contract, or by the acts and conducts of the parties. So that particular contract is a contract where you are going to get the collection, or you are going to collect the information or the evidences of that particular contract, or by the acts or the conduct of that particular parties, and not from written or spoken words of the parties. So here you are not going to take whatever they have written or whatever they have spoken about the agreement or the contract. Now example, it says implied contract example, you can see here A is taking a cup of tea, that is in a restaurant, or he can get into a public bus, or he can lift the B's luggage to be carried out by the railway station. So these are the various examples we can give for this implied contract. Now coming to the next example, one more example, it says A fire broke out in peace farm, that is there is a fire taking place in another farm, that is in one of the parties' peace farm. So A and P are the parties here. So here it says fire broke out in peace farm. So what happens? A will immediately call the P, and the authorities, the fire authorities, they will come and they will extinguish the fire. But the house which is been located of P, it is not under the zone which is coming for free kind of service. So under that particular contract, they say that he is applicable for paying the amount for the services which has been rendered by this particular persons or that particular authorities. Now coming to the third type, whether it is constructive or quasi contract. See, constructive or quasi contract is nothing but, it says a quasi contract, actually it is not a contract itself, because you are not going to do an agreement or a contract between the parties. Here it is just made by out of law. So it is just out of law, this contract has arisen. So it is not a contract which is made intentionally. There is no intention to do a contract between the parties, right? And there is exchange of promises. So there is no exchange of promises, nor there is any intention of doing a contract, coming into a contract. So it is a contract which has been imposed by law. So quasi contract is what? It is a law. It is a contract which has been imposed by law. So here the basis of this particular contract is what? It says that no one can be allowed to enrich himself. No party will be allowed to enrich himself. That is, should not get the benefit without making an agreement. So no party should get the benefit, or he should not get enriched with the benefit of the other party at the cost of other party. So here example we can say here X is a tradesman. He is a tradesman and he is keeping his goods in C's house. He is keeping the goods in the C's house. Now this person, without making agreement, without there is a valid contract, he uses C's properties or the goods or the commodities which is kept in his house. In that particular case, he will be imposed by law. So he is bound to pay for the goods which is being used by him. So he is bound to pay for the goods which he has used or utilized. So that contract is called as the constructive or quasi contract. Coming to the next type of contract, under this it says e-commerce contract. Everyone knows e-commerce. What is e-commerce? Electronic commerce. So here the contract here made between the parties will be not physically, but it will be through digital mode, or it will be through electronic mode, we can say, right? That is through via internet, and here the internet, the individuals or the companies, who are entering into a contract, they will be creating the new networks. They will be creating the new networks, and that particular networks will be linked to numerous other networks, and thereby you can see it expands the area of operation of the commodities or transaction in which they operate by any of the person. So I'll explain to you once again. It says e-commerce contract is a contract where you're not going to, in simple words I'm saying. So e-commerce contract is a contract where you're not going to do the agreement or the contract between the parties in the means of physical mode, but it will be done through electronic mode, that is through via internet. So all these internets will be connected to a network, and that network will be connected to all the various other networks, and thereby you can see it is been linked, and the area of operations also will be expanding for doing the transactions of the persons. So this is about the e-commerce contract. Students, now coming to the next type under classification of contracts, that is on the basis of execution. What do you mean by execution? Means performing the obligation. So under this we have executed contract, and second one is we have executory contract. So executory contract and executed contract. What is an executed contract? An executed contract is nothing but it is a contract where before entering the agreement, the obligation is being completed on both the parties or by both the parties. So when both the parties to the contract who are there, if they have completely performed their share of duties or the obligations, right, and nothing remains to do so, nothing remains to do by either of the party, then under this contract, then it is called as the executed contract. So executed contract is nothing but it is a contract where it says when both the parties who are coming under a contract and who have completed their obligations, and there is nothing to do further. So that kind of contract is known as the executed contract. Example, you can see here, A agrees a paint of picture for B for rupees 1000. So A is agreeing to paint a picture for B. Like for example, I am A. So I am agreeing to paint a picture for my friend B, right? And when A paint, that is when I paint the picture for my friend B, and he pays the price for it, and he will pay the price for it, then both the parties have performed their obligations. Both the parties have performed their obligation on their part. So I'll explain to you about the example. Myself, A, I have promised to paint the picture for my friend B. Now after finishing my obligation, after painting work is completed, now B is paying me the amount. B is paying the amount to me. So when he pays, then automatically that obligation or that particular contract comes to an end. That means both of them, that is myself and my friend, we have done our duties. There is no other duties to be, or there is no other obligations or the performance to be done. And there is, in some cases it says, even though a contract may appear to be completed. Now I told that I have painted a picture to my friend and he has paid me the amount, and thereby the obligation is over. But sometimes it will not be so. It will be continued. Now you can see here, when a person buys a bun containing a stone. So if a person is going to a bakery and he is buying a bun, and when he eats that, he finds a stone, and that particular stone will harm the teeth or the tooth, and thereby there is a loss or the injury on his part of that particular person. Now there is where he can go and claim the compensation. So here it says, subsequently he breaks one of the teeth and he has a right to recover the damages from the seller. So he can recover the damages from the bakery person, right? This is the extension of that particular contract. Now coming to the executory contract. What do you mean by executory contract? Executory contract it says whether either parties have still to perform their share. Now here it is not been executed. The obligation is not been over. It is not completed. It is still pending. It is still due, where on both the parties have to perform their obligations on their part, right? So which is not been done by both the parties. So when either parties have still to perform their obligations or the share of obligation, and there remains something to do, and thereby under contract of both the parties. So under this particular contract, so there is some pending obligation, or they need to do their part of obligation, or it has to be completed. So that particular obligation has not been completed on either of the parties of the contract, and that particular contract is called as the executory contract. So in this example it says the contract is executory if A has painted for B the picture and B has not paid the price. So in that case what happens? What he can do? So A can agree to engage B as a servant in his house. So here, as I told you, I am asking my friend to paint and he is painting it and I will be paying him. In case if I don't pay him, then according to this particular contract, that is executive contract, it is due on my part that I need to pay the amount to him, which I have promised. So in that case, if I have not paid, then I can take him as a servant in my house, right? And make him to work and give him whatever the amount which is due to him, or which is to be paid to him. Now students, on the basis of performance in relation to parties, we have two types. That is unilateral contract and bilateral contract. So bilateral contract and unilateral contract. What is unilateral? Uni means single. Bilateral means two. So here, when one party has to perform his obligation, right? And the other party has performed his obligation at the time of formation of the contract, then or before it, then this is why it is called as one-sided contract. So at the time of entering into contract, if already one of the party has already performed his obligation before entering the contract, and the other party has still not yet completed his obligation or his share of obligation on performing his obligation or the duties which he has promised, then that is called as unilateral contract, because it is only one-sided contract. Only one person has fulfilled the obligation, the other person has not done so. So example, you can see here, A permits the railway coolie to carry his luggage and place it in that particular carriage. So A is a person who is asking the coolie of that where he is working. That is, A is asking the railway coolie to take the parcel or the luggages and place it in the carriage. So here A contract comes into existence as soon as the luggage has been placed. So here the A's contract will come into force, right? It will come into force as the luggage has been placed in the carriage. When the luggage has been placed in the carriage, but at that time the coolie has already performed his obligation. He just says, come on, place it on that particular carriage. Take my luggages and place it on the carriage. By that time, he finishes saying that particular and having a contract between themselves. This person B, that is the coolie, he has already done his work. He has already done his obligation. He has already completed his obligation, and thereby it says now A has to fulfill his obligation, that is to pay the reasonable charges to the coolie. So when he has already done the duty, A has already done the duty, that is the obligation of the other party B, where he is to pay him the amount for carrying on his duties or the obligations on part of A. Now coming to the bilateral contract. Bilateral contract, it says where the obligation of both the parties are outstanding. It means at the time of entering a contract or at the time of contract, here both the parties have not completed their obligation on their part, which they have to do it. In that case, it is called as a bilateral contract. When both the parties to the contract has not completed their share of obligation or their part of obligation which is not been completed, then it can be called as the bilateral contract. Now, this particular obligation are outstanding at the time of entering into a contract or formation of a contract. At the time or at the formation of a contract, if both the parties have not completed their share of obligation or not completed their obligation or the promises which they have made at the time of contract, then it becomes a bilateral contract. So it is also a contract with executory consideration. So it is similar to the executory contract. So these are the various topics which I had covered to you today, that is regarding the classification of contracts. Now I'll just summarize whatever the topics which I had covered to you today under this particular session. So I explained to you about the classification of contracts. So classification of markets is based upon execution, enforceability, duration and creation. So under this we have various different types of contracts. Under enforceability, we have valid contract and it is voidable contract. Then under third one is the void contract and void agreement, and enforceable contract, and last one is, and next we have on the base of creation. On the base of creation we have express contract as well as implied contract. Then third is the constructive or the quasi contract, and fourth one is e-commerce contract. The next part is on the base of execution. We have executed contract and executory contract. Then on the base of performance of the relation to the parties, we have unilateral contract and bilateral contract. So these are the various topics which I had covered to you today in this session. Say that to all my students, please once again after the class, sit silently and just memorize whatever the explanation which I had given to you in today's topics. That is, silently you sit and just memorize, and it will be helpful for you on the part of examination. So if you are attentive in the class, it will be helpful for you in the examination, because you can just make the points what I explained to you, and you can write it on your own, and you can elaborate and you can write on your own for even for 15 marks or 10 marks also. So always be attentive, have concentration, and see that you prepare well for your examination from the day of one itself. By saying this, I would like to end my class for today. See you all in the next class. Until then, I wish you all the best, good success, good health, and take care. Bye-bye.